Why are at-will employment cases so controversial? Imagine a workplace where either side can end the relationship at any moment, for almost any reason. That's what at-will employment is all about. It's the default in most U.S. states, meaning employers and employees can part ways without needing a specific reason. But this setup often sparks debate. Why? Because it gives employers broad power to dismiss workers without much notice or explanation. Employees might feel vulnerable, worried they could be fired suddenly and unfairly. One big concern is job security. When employment is at will, workers have no guaranteed time on the job. An employer can decide to end employment at any time, which can cause stress and uncertainty. People want stability, but at-will rules can make that hard to find. Then there's the risk of abuse. Employers could dismiss employees for reasons that are unfair, discriminatory, or even illegal, like firing someone because of their race, gender, or age. Proving these motives can be tricky, which adds to the controversy. Legal exceptions also complicate things. Even though at-will employment is the rule, there are important limits. For example, firing someone for illegal reasons such as discrimination is not allowed. If an employee is fired after filing a workers' compensation claim, that could be wrongful termination. Sometimes, employer statements or employee handbooks create implied contracts that suggest the employee will stay longer. These implied contracts can limit the employer's ability to fire at will, leading to legal disputes. Another issue is the imbalance of power. Historically, courts assumed workers and employers had equal bargaining power. But today, many see that employers often hold more economic and structural power. This makes the at-will doctrine seem unfair to employees who depend on their jobs for income. When it comes to employment contracts, if a written contract states specific terms about firing, it can override the at-will presumption. But many workers do not have such contracts, so they remain at the mercy of at-will rules. Employers often include disclaimers in employee handbooks to clarify that employment is at will. Still, courts sometimes find exceptions based on employer conduct or policies, which can lead to legal fights. Overall, the controversy is rooted in the tension between giving employers flexibility to manage their workforce and protecting employees from sudden, unfair dismissals. It's a balancing act that continues to spark debate in employment law.